Going to ask for it quickly.
Yeah, there he is. Ed Martinez, folks, ladies and gentlemen. How
Back.
are you?
We are
Thank you
back.
for thank you for joining us for today at your service with Haber and Martinez, episode number 42. We've labeled today as part two of our Up X2 series. Today is Lawyer Up or Invoke the 6th or the Sixth Amendment. And it's part two because we already did part one a couple of weeks ago, which was Shut Up. And that was your Fifth Amendment and your Miranda rights video. Anyhow, our producer is going to help us. We've got, just like we did with part one, we're going to use some demonstrative tools here. Let's pop up our first slide, slide number one. Thank you. Is there a way to make that so it's a separate box so Ed and I can talk?
Oh, nobody wants to see my face.
Yeah, I do.
They can
I
hear
like
my
to see your
voice.
smiling face. If you can put that into its own box, Julian, that'd be great. If not, I'll just talk over it and tell you when to remove it. In
Yeah,
any
just
event,
get started.
this is an old ad that we used that we created a while back, and this essentially sums up what Up X2 is, or as I call it, hashtag Up X2. It means lawyer up and shut up, or shut up and lawyer up. Invoke the fifth and invoke the sixth. You can take down slide one now if you don't mind, Julian. Thank you. So I want to talk a little bit about how we got to this point. And historically speaking, put up slide two for a second. Again, thank you. Anybody recognize these guys? How
I
about
think I
slide
see.
three?
I think I see you sitting back there, though.
How about slide three? Do we have slide three available?
Was that you?
There we
Was
go.
that you, Mike? That was you sitting back there, wasn't it? I
So
saw
they
you.
all have way more hair than I do, Ed. This is the Sixth Amendment to the U.S. Constitution. I'm going to leave it up there for a minute while I give you a little bit of a history lesson. I'm going to wrap it up real quick. You all know that our Independence Day is July 4th. And that's because on July 4th, 1776, the Declaration of Independence was adopted by the Continental Congress. Interestingly enough, it wasn't until August 2nd of that same year that it was, quote, engrossed on parchment. In any event, the Bill of Rights, that is the first 10 amendments to the U.S. Constitution, otherwise known as the Articles of Confederation, did not come into effect until December 15th of 1791. So it was 15 and a half years later that the Bill of Rights were adopted. And the reason that this happened was because we were still going through the struggle of how to form the perfect union that we wanted. And it was the Federalists versus the Anti-Federalists at the time. There were 13 separate colonies, each acting independent, and each of the 13, only 11 of them had their own constitutions, and only 7 of those 11 had bills of rights. So it took this whole period of time from July 4th, 76 until December 15th of 91 for these first 10 amendments to come through. So I just want to kind of read the sixth, because when you guys hear the Sixth Amendment, really most people think about the right to counsel, and perhaps that is the biggie, but that's not all that the sixth contemplates. So as you can see, the Sixth Amendment to the U.S. Constitution says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witness in his favor, and to have the assistance of counsel for his defense. Thank you, Julian. You can take down slide three now. So,
I saw a guy once engross on parchment, but it was in Thailand. I don't think it had anything to do with this.
cute. So, as you guys can tell, the sixth is a pretty significant paragraph. It has a lot of different rights, and during the course of this video, we're going to hit each and every one of them. We'll do speedy, we'll do public, we'll do impartial jury, we'll do venue, we'll do jurisdiction, notice, confrontation, compulsory process, and then assistance of counsel. As you can imagine, we could easily spend a full day on this. We could probably spend a week on it if we wanted to. Consolidating this into an hour is really tough. So we're going to try and hit the most salient points and do it in a way that will, hopefully be interesting and entertaining, which we try to do each and every week.
And if I can
And
jump
you
in
look like you're
briefly,
dying to say
I
something.
just want to say something briefly. This is why you need to have somebody who understands this area of the law, not just a lawyer. You can't have a family lawyer understand this part, or a contract lawyer or a real estate lawyer, because what Michael and I have in our own heads, we could go through and take a week to tell you. So when you hire us or somebody who knows criminal law, all of this comes to us quickly, instinctively. It's an easy flowing machine. Don't think you understand it, and for God's sake, stop trying to tell us what we know. We know what we know because we've been doing this for so many years, and we're going to try to put all
So,
this down, and it's going to be hard for us because of how much knowledge we have in here.
as a quick aside, just to hop on what you just said, I have a case right now. It's a domestic violence, just a basic battery misdemeanor DV case. The victim, the alleged victim, the complaining witness, as we like to call them in that case, took out a civil restraining order against my client. He's represented by a family lawyer in the civil case. I don't represent him on that. But these things are happening in real time, concurrently, at the same time. So part of the problem that my client has is he's got a family court judge that's eager to resolve this family court case, and he's got a criminal case that's taking time to get resolved. So the rules and the procedures are entirely different. The burden of proof is entirely different. There's no similarity between these two things, except that they happen to stem from the same facts and circumstances, but they diverge into two completely different and independent things. So I had a bit of an argument with the family lawyer the other day because he's complaining to me that I'm taking too long and his client, our mutual client, keeps getting set for deposition, and that the deposition has to be taken. The judge is giving him a hard time, blah, blah. I said, listen, I don't know what to tell you, but if my client shows up for a deposition in your case, I am going to tell him to plead the fifth as to every single question that he gets asked, including his name. I don't want him answering anything. And then all we're going to do is wind up delaying. So I only bring that up to back up what you said. It's entirely true. This family lawyer does not know criminal law. And if he had any inkling about criminal law and he understood the Fifth Amendment, Part 1 of UpX 2, shut up, right? If he understood that, then he would not be giving me a hard time about his deposition in the civil case and how critical that is.
Right. And if the
So,
judge, some judges get it, some judges do, thankfully, who have had an opportunity. And again, it's not because they're bad judges or anything like that nature. Just a judge who's had an opportunity to work both areas for a little bit. Like you can't just say I had one case. That's not going to cut it. But if they had a little bit of experience in both areas, those judges are a joy to work with because if they've done criminal and they're in family, they get it, or vice versa. And they really do. Honestly, I've had good luck with almost every single judge I've been in front of. They really try to work with both parties in both areas, but they also have a job to do, and I get that. So
let's get moving. Speedy trial. Let's speed things up. So with speedy trial, I want to talk about a couple of different things. First off, there's a difference between constitutional and statutory speedy trial. So the Constitution grants you a right under the Sixth Amendment to a speedy trial. That applies both federally and to the states vis-a-vis the 14th Amendment due process clause, right? So what that means is basically in the old days, and remember our entire system of government, the reason that we have the system of government that we have is because all of these folks came across the Atlantic from west to east, and they landed here in a new country and a new land, and they brought with them what they knew from their original land, which in most places was England or other parts of Europe. And what they knew was the common law. They knew what it was like to live under a monarch and to have that type of a regime. So if you know anything of our history, you understand that the reason that we are a country is because the colonists over time decided we don't want to be governed by a monarch who's 4,000 miles away. We want to be governed on our own, in our own way, as it's supposed to be. Right. So because of this, we established a constitution and we established certain rights, all right? And the speedy trial provision goes directly back to the idea that when somebody in the monarchy, when the king got it up his ass that you needed to be dragged in front of the king, they'd literally rip you out of your home, throw you in a cage, and let you rot there until they were ready to deal with you. So there was no such thing as any requirement that the king give you notice, all the things that we're going to talk about under the Sixth Amendment. None of these things existed at common law. The king wasn't bound by public trials, speedy trials, impartial juries. The king did what the king did, or ordered that other people do what the king wants at the king's behest. So that's really where all of these things come from. But with speedy trial, that's the particular background. It is intentionally designed to prevent from oppressive incarceration pre-trial. That's the bottom line with speedy trial. It protects against the government from just allowing time to pass. But if you think about it, also in a way, speedy trial protects the individual, but it also protects the government, right? So think about it this way. Ed, how many times as a prosecutor did you have a case where the defense continued it and continued it and continued it and kicked it down the road until all of a sudden one of your witnesses was dead, or you couldn't find the evidence anymore, or the police officer retired?
You mean when I was a prosecutor, correct?
Yeah, when you were a prosecutor, how many times did you have to deal with the
Well,
judges granting defense continuance after defense continuance, and then all of a sudden your case got screwed?
That's one of the biggest concerns for a prosecutor, especially with civilian witnesses, because not only do they die, sometimes they just get sick and tired, and they're like, you know what, I want to move on with my own life. I don't have time for this crap. So a prosecutor has to take that into account. And a lot of judges, if the prosecutor lets the judge know, listen, the defense attorney's playing games, the judges will stand up and say no more. But that's one of the concerns. Now, when I was in narcotics, not a concern, because it was all detectives, and maybe one would move, but they know that they have to come back if they retire. So that was actually one of the beauties of being in narcotics. I didn't have to worry about any of that.
So we have two different types. Again, you have statutory and you have constitutional here in the state of Florida, and every state has their own independent rules. So understand, again, when Ed and I talk, primarily what we're talking about is Florida state court. Although every now and then we'll talk about federal, but be clear, if you're in some other state, while the premises may be the same, the rules could be very different.
Yeah, and
So
for,
in any event,
for the record, the majority of the Florida statutes on these procedures and whatnot mirror the federal. If you look at it, our number actually starts with a 90 point, but it usually, a lot of times, it's the same exact statute number that's federal. So that's how you know.
So when we talk about speedy trial here in Florida, you have what we call natural speedies. Natural speedies start when you're arrested. If you are taken into custody, if you are arrested, then from that moment forward, speedies are ticking. In the case of a misdemeanor, the government has 90 days from the date of your arrest under natural speedies to take you to trial. And in the case of a felony, it's 175 days. Contrary to popular belief, your case does not get dismissed if they blow the speedy window. It's the obligation of the defendant at that point, assuming that he has not caused any delay, no delay is attributable to the defense, then the defendant has to file what's called a notice of expiration. And that notifies the court and the state, hey, the allotted statutory time has ticked. Natural speedies have expired, and you're now on the clock. You need to take me to trial. Now, let's not get into the COVID, which, screwed up speedies and has thrown a monkey wrench into the machinery of the system. But suffice it to say, all things equal, absent COVID, that was the rule. The court then had what's called a 15-day window of recapture within to start the trial. And if they didn't start that trial within 15 days, guess what? You won.
Well, the state has 5 days after you file. Remember, though, there's a. I know that we do this.
So the total window is 15 days. So I don't want to bog down in specifics.
Okay.
The one thing I want to give you as a pro tip, where this does not apply, traffic tickets. If you get a speeding ticket or an infraction, not a criminal traffic case, but an infraction, there is a flat, drop dead 180-day time period. So if they don't schedule you for trial on the 181st day, don't worry about it, because your case has to be dismissed unless you took a continuance or caused a delay. Just for shits and giggles, real quick, put up slide 4A for a moment, and then we'll do 4B. I can't read 4A because the screen has got it blocked up, but just so you guys can, there you go. I can promise you a speedy trial since you don't have that much money. That's not what the speedy trial rule is about. That is a joke, folks. Put up B, please, Justin, 4B. Julian, I'm sorry. That is a written demand for speedy trial. It's a physical document that simply says, comes now the defendant by and through undersigned counsel who hereby files this instant written demand for speedy trial pursuant to Rule 3.191. that is what we are required to put the government on when we want to accelerate the case. Thank you, Julian. You can take that down. So why am I showing you that? Because that is one of the very few weapons in the defense attorney arsenal that allows us to really take control of the case. When we drop that speedy demand, the court is now bound. Again, forget COVID. Let's just stick with the statutory rule. It's 50 days. The
Right.
minute
So
you
just so we're
drop that,
clear, and I don't know if you made it clear, but I want to be crystal clear with everybody. So what Michael is talking is about the natural speedy. So for example, suppose we get a case and we have to take a continuance on, the first or second time up. Well, those natural speedies are gone forever. However, we still have this tool in our arsenal. As soon as we're ready, and we have to be ethically ready,
right?
Michael or myself can file this, and that's one Michael has filed in the past, where now the number is much narrower, right? So go ahead, Mike. I just want to make sure we're clear about
Yeah. No, so the point is, you could drop a written demand for speedy trial the day after you're arrested.
True.
Doesn't matter. You could do it at any point. But whether you have a natural speedy window running or you've blown natural speedies, your case could be 3 years old. It doesn't make a difference. At any point in time, the defense can drop that written demand, and that will now accelerate and prioritize your case. So that's a weapon. But again, as Ed said, it's really important to note, you don't throw this around casually. It's like a hand grenade. You have to be very careful with it. If you screw it up, you're held to it. So you need to be certain. What you're saying to the court at that point in time is, Judge, we are ready to pick a jury right now in this moment. And what it says to the court is, the defense is ready to pick a jury right now in this moment, and I have to do this within 50 days or I create a problem.
And I'll tell you what happens if you do it and you're not careful with it. Because there's the law, and then, like I told my clients, I'm sure you do too, Michael, there's the law and then there's reality. Okay, you get a reputation for dropping speedy demands just to see if the state is actually ready, and then having to withdraw them at the 11th hour. Forget the fact that the judges are going to start talking to each other and they're going to remember how full of crap you are. I'll tell you what I did once as a prosecutor. I knew this guy used to do this. He dropped the speedy demand. He thought we were going to come in because typically, right, Mike, you drop the speedy demand, the state comes in and says they want the trial done 20, 30 days from now, 5 days, whatever the recapture period is, right? He came in and dropped the speedy demand. I looked at the judge and said, Judge, we're ready. Let's pick a jury right now. Let's bring them down right now. Because the state gets to choose the date. I said, I want it right now. He wanted a speedy trial. He's going to get his speedy trial right now. Let's bring a panel down. And of course, he had to withdraw. And he looked like an ass. So this is why Michael and I have a very good reputation in this county, not only with the judges, but with the state attorney's office, because we always have to do the right thing. And sometimes, guys, it goes against what you want. But despite what most people think, most lawyers are not liars. Okay.
Let's get on to our next issue here in the Sixth Amendment, and that is a public trial. And again, a public trial, just like the same thing with speedy trial. Back in the day, you were worried about, I don't know if you've ever heard the term star chamber, but a star chamber is a term that refers to a secretive proceeding. You may consider, like, the Spanish Inquisition is another great example. These are situations where people were simply taken into a room and convicted. Like, if you've ever seen the Dark Knight movie, where the people get hauled in front of the guy and they're like, death by execution or death by
expulsion. I think it was expulsion.
Right. Whatever it is. But he said, and they're complaining about due process, and the guy says, no, your guilt has already been established. This is merely a sentencing hearing.
There's an actual movie called Star Chamber with Michael Douglas, where he's a judge.
So that's what a public trial is for, okay? It was basically,
by the way, it's a good movie.
It was basically so that there were no secret proceedings to be had in this country. It was to make sure that the judiciary was open to the public to be able to see what was going on, so that there were clear processes and protocols that people could observe with their own eyes. Interestingly enough, and we do see this today with technology a little more. I guess really maybe the first really big one was OJ, right? Where the whole trial was televised. And you do see it periodically in some cases. For example, Johnny Depp and Amber Heard, it wasn't a criminal case, but it was just on trial on TV. So, and there is court TV and all those sorts of stuff, right?
Mike, you went blank.
Am I?
You're blank. I can hear you, but I can't see you.
All right, can you see me
I
now?
think it was a little, now that I think about it, do that again and just leave it like that.
So in any event, there are some instances where courtrooms can be closed, but interestingly, state court proceedings, at least here in Florida and in many other states, as we can see, just like we said, they just did this in California. And where was Johnny Depp? In Delaware or something? So
Virginia. I think Johnny Depp was Virginia.
So they you can see that those states permit it, but what you will never see is a federal court trial on TV, which is absurd. It disgusts me. It infuriates me. I think the federal court system still operates very much like a star chamber, and it shouldn't. It is unfair and I think wrong. Julian, put up slide 5 for 1 second. Reference public trials. I can't see the language underneath it, so I'll read it. Oh, there you go. Your Honor, we feel that this trial failed to deliver on its pretrial publicity. You could take that down, Julian. Okay, so it's a public trial is not supposed to be a trial in the court of public opinion. It's supposed to be a trial that's open to the public. It's so that things are exposed and not hidden. It's not so that things can be decided beforehand. So we're now going to hop on to Ed's favorite, his personal favorite, an impartial jury trial.
Pet peeve, because everybody, I've heard lawyers, I've heard judges tell a jury that this defendant is entitled to a jury of their peers.
Before we get into the peers, I'm going to let you handle that. But let's talk about what an impartial jury trial is. Okay? An impartial jury trial is designed to prevent government oppression. Are you seeing this theme as we hit each of these points on the Sixth Amendment? The reason that we have an impartial jury trial is to protect against unfounded criminal charges. The judiciary is supposed to be an independent proceeding, but we know that whether they're elected or appointed, one way or another, judges are politicians. Period, paragraph. I'm not saying they're partisan politicians, but they are politicians, meaning they have a vested interest in keeping their job. And they either keep their job by getting reelected, which necessarily makes them a politician, or by being reappointed, which also makes them a politician. So the jury is a check valve against corrupt prosecutions and biased judges. That is the entire purpose of a jury. I want to give you the exact language.
Well, while you're looking that up, let me make sure.
No, I've got it right here, and then I'm going to hand it off to you.
Okay.
Impartiality of a jury does not mean that you're entitled to a jury of your peers. It means, and the quote is this, you are entitled to a cross-section of the community. That's what you're entitled to. So, with that said, I'm going to let Ed run. Oh, let me just put up slide 6, and then I'm giving it to you.
Yeah, as you're putting up slide 6, go ahead.
So, go ahead. We can't read the bottom
jury
of it again, Julian.
Jury of my peers, that's a laugh, and what's the rest?
How many of you have ever killed a guy?
Correct.
So
that's very apropos.
You can take that down. So with that in mind, as you can understand, look, you may be a white person who has no white people on the jury. You may be a Latin who has no Latins on the jury. You may be an electrician who has no electricians on the jury. You may be a murderer who has no murderers on the jury. A jury of your peers does not mean that you're entitled to people that look and act and think like you. Ed, take it from there.
That's really the point is we got to get that word out of our vocabulary when we talk about this part of the Constitution. It is not a jury of your peers. Never has been, never will be. Because like that little cartoon illustrates, correct, the jury of that guy's peers would have to be somebody who's murdered people. We can't do that. I just want to clarify one thing you said about judges being elected and politicians. That's in state court, because in federal court, they're appointed and they're appointed for life. So,
which still makes them politicians, because how do you get appointed?
But you would think once they get appointed, they'd be better, but sometimes they're actually worse because now they know they can't lose their job. But that's a story for another time. And some judges are great. Most of them are. But here's the point. It's what Michael read. You're entitled to a cross section, right? Because what's fair is for the entire community or representatives of the entire community to be able to sit down as your trier, as your juror, as your trier of fact and say, okay, I may not be, let's say I'm on trial. I'm 56 years old and I'm on trial. I might have a 26-year-old or a 30-year-old woman, black woman, who's never had my experiences, but she lives in my community. So she has a right to be on that jury to say, I want to be here to decide what happens to this man who was accused of whatever I may have been accused of. So it is a cross section of your community, and it is the people in your community. And then they have to be impartial. And what does that mean? Well, we know the most obvious ones, right? Michael couldn't be on my jury because he's my friend. I mean, they don't know Michael. He'd probably be rooting for them to convict me, but you would assume that my friend would be like, nah, you know what? I know I did it, but I'm going to throw him a bone. Can't do that. Family members. But what are other things that might make you impartial? For example, if I murdered somebody, having somebody who was accused of murder on the panel, that might make that juror not impartial because he might think, shit, I know what he's going through. Whether he was innocent or guilty, it doesn't matter. He might sit there saying, you know what, I've been there. Poor guy. I know what he's going through. And then he's not going to judge based on the facts. He's going to judge on something emotional. So it's impartial. People that have no stake in the game, no skin in the game, couldn't care less one way or the other what the hell happens. They just want to know.
And peers is the word that we need to be concerned about.
That's the one we got to get rid of our vocabulary. Out.
Okay, so let's go to our next point, which is venue and jurisdiction. So basically, I want to just let you know that what this really means is two things, okay? Venue is where is the appropriate place for a trial to occur. And jurisdiction refers to the power of the court to conduct a trial. So they're two different things. The 6th deals with venue, not with jurisdiction, okay? So venue means that if I commit or I'm accused of committing a crime here in Miami, it wouldn't be appropriate for me to be tried for that crime in Minnesota, okay? Right. There's no relationship from the offense to the place where I will be actually tried. But it is possible that venue occurs in more than one place. And it does happen very routinely where we have cross-jurisdictional lines, right? Especially a place like, let's say, Miami. How many times do you have somebody who commits a crime in Miami and then flees up to Broward or flees down to Monroe or vice versa? So you wind up with all these different police agencies involved and who ultimately winds up charging the case. So the general rule of thumb is you're not supposed to be sequestered. And again, it goes back to England, right? Because let's say that you were taken into custody in Sussex. They might transfer you to Winchester, okay? Because they could, because nobody could say no, because whatever the king decided, right? Here, we say wherever your crime occurred is where you have to be treated. Now, I will say that there's a little bit of leeway here, especially in federal court, right? If you have crimes that cross interstate boundaries, crimes that affect interstate commerce, they might happen to have proper venue in any jurisdiction. And especially when you deal with complex racketeering type offenses or criminal conspiracy type of offenses, right, and you've got people from all over the country that are involved in the same thing, they've got to pick one place to try the case. And it's not going to be where everybody is. A lot of those people are going to have to be transported or physically make their way there.
A lot of times that's going to be determined by the prosecutor when he files the charging document. He'll have language in there that'll point to a specific.
And we're getting to that. We're getting to that next. But let's put up slide 7 real quick, just so that the folks can maybe get a quick venue idea here. My client requests a change of venue to a jurisdiction where his criminal activities are not a crime. Thank you, Julian.
So wait, he wants to go to California?
That's kind of the point, right? So if they've decriminalized hard drugs like, cocaine and fentanyl and mushrooms and whatever, hallucinogens in Oregon, well, if I got arrested here in Florida, sure, I'd love to get a change of venue to Oregon because it's not a crime there. That's not how it works, folks. You are tried where the crime occurred.
Well, and the rationale behind that is the same as what goes to the jury panel, right? This is the community that allegedly, because that's another thing that comes up a lot with the prosecutor, with victims. Victims will call and complain to when you're a prosecutor saying, you're my lawyer. We have to explain to them, we're not. A prosecutor is the lawyer of the people of the county or the jurisdiction they're in. So in Miami, you're the prosecutor for the people who live, the citizens of Miami-Dade County. And so what happens is if you commit a crime in Dade County, the prosecutor is prosecuting you on behalf of the citizens in Dade County who ostensibly through their politicians have decided that this is a law that they want enforced in their county.
It's pursuant to the laws of the state of Florida, but
they're
limited to their jurisdiction.
But they want these laws enforced because they voted for them.
Let's get on to our next one. In their county. Notice. So Ed talked about the information. Okay, we have the functional equivalent of an information is an indictment. An indictment is a formal charge by a grand jury. An information is a formal charge by a prosecutor instead of a grand jury.
Right.
So in the federal system, everything has to be done by indictment unless it is specifically waived. There are protocols for things to be waived and people to proceed on what's called a criminal complaint, which is filed by an assistant United States attorney. But in state court, the only cases that are indictable, I mean, I guess they could seek an indictment for anything, but the only cases that are required to be indictable are capital felonies. Otherwise, the prosecutor can charge an information. The point is, Sixth Amendment requires notice. Because again, why? The king could drag you out of your bed in the middle of the night and throw you in a cage and keep you there for however long he wanted, and you may never know. You could die before you ever found out why it is that you were there in the first place.
Or how about
We
taking
don't
a
do
trial
that.
without you being present, never having told you anything?
We don't do that here in this country, okay? We are required under the Sixth Amendment of the United States Constitution to provide anybody who is accused of a crime with notice. They're entitled to know what they are being accused of, when they are accused of having done it, where it allegedly occurred. That is the notice requirement under the Sixth Amendment. You need to know what it is that you're defending. There is no obscured, unspecified allegations in this country. Just put up slide 8 for 1 second.
And then I want to get to another one of my pet peeves on that.
That was an easy one. Legal notice. Okay, you can take it.
I want to get to one of my pet peeves. I'm sick and
Quick.
tired of seeing these videos where everybody says when a cop pulls them over, put your hands behind your back. Or what am I getting arrested for? You have to tell me. No, they do not. Only in this, when you get to this point, when you get to the point where the prosecution is saying you're being charged, that's when it's official.
That's going to dovetail. That's going to dovetail into our last piece, which is assistance of counsel. Let's go to the next one, which is confrontation. We are confrontational. Just put up slide 9 for 1 second for us.
Well, that's what your ex-wife accused you of.
So, bring the hamster out here. I demand to meet my accuser whiskers to whiskers. Okay, thank you. You could take that one down. The primary purpose of the confrontation clause in the Constitution is so that you are not tried by document. Okay? In other words, we don't want the government to just get up there and repeat things that other people said, whether it's because they wrote a statement or because they're just telling you what they were told or what have you. It's called hearsay. And there are rules against hearsay, although there are a lot of exceptions to the hearsay rule. As a general rule, you are entitled under the Sixth Amendment to confront your accusers. Okay? The language that the Supreme Court uses is an accused must be able to test the recollection and sift the conscience of witnesses. They must be able to stand face to face with the accused so as to look at and judge by his demeanor upon the stand and the manner in which he gives his testimony, whether he is worthy of belief. That's the whole point of the confrontation clause. It's not enough for me to say Martinez pulled a gun on me. The jury needs to be able to assess my credibility as a witness. And the only way they can assess my credibility as a witness is if they meet me. And it's not enough for the government to just put me on and let me tell my story and walk away. No, I have to be subjected to cross-examination because that's how the defense is able to show whether or not I have bias or motive, or if I'm lying, or if I'm exaggerating, or if there's some reason for me to not know what I'm talking about. There are any of a billion things that Cross might let go. Confrontation becomes really important to us because we cannot be in a position where the government gets to parade police officers in and say, well, Susie told me that this guy did X, Y, and Z, so he must be guilty. No, Susie's going to have to get her butt in the courtroom, absent the most extreme of circumstances. We see this a lot, and Ed, take 30 seconds or 45 seconds, if you will, and talk about a great application of the confrontation clause is when dope cases are made by narcotics detectives using confidential informants.
I can talk about that, but you want me to limit myself to 45 seconds? I haven't been able to do
minute.
that since I started talking as a child.
Take a minute.
No.
Confrontation, just in regards to confrontation. I don't want to go
That's just quickly on what you said.
Yeah.
The other reason why they have to appear in court, some people come into court and lie, and we know they do. You put them under oath, they don't give a crap. They're going to lie. They're going to do whatever they want. However, there are a lot of people that might tell a cop something, and they kind of embellished a little bit, maybe even lied. But now when they're sitting in a courtroom, they have to swear under oath. They're like, hell no, I'm not doing that. I'm not. I can't do that. So you're going to weed those ones out. And then the ones that are going to come in, like Michael says, you get to be confronted, question your story, make sure it's right, and all those other things. When we do the narcotics cases, when a CI, which is a confidential informant, is a person who witnessed the events or was the one who did the events, that person has to be disclosed. Why? For the same reason that every cop that's on the scene is disclosed. Because even if Michael's an undercover UC and he's got the CI with him present, you can't just let Michael come in and talk about what happened, because that CI at that moment was working under the color of law. He was working like a cop. So the defense has a right to have access to that guy to make sure that what Officer Michael Haber said is true, because that guy was there. And there have been instances, Michael, I'm not going to say who, but there have been instances with former prosecutors who didn't understand that, or they knew it but just didn't give a shit, and went to the scene. Some of them went innocently, thinking nothing was going to happen, and all hell broke loose, and they kept the case. And a prosecutor cannot do that for the same reason. If you're there, you have made yourself a witness, and you got to get out of that case. And this is why, because the accused has a right to confront everybody. Bring everybody in who saw it, because maybe the CI is going to say something different than what Officer Michael Haber said. So this is important in our system.
Let's get on to compulsory process.
You proud of me? Was that short?
No, that was good. Slide number 10, if you don't mind.
I want a little appreciation, man. Kept it short.
As we are running late for lunch, I'm going to dispense with the case for the defense and go straight to sentencing. Thank you, Justin. You can take that one down. So compulsory process, in a way, is going to dovetail with our next topic, the last one, which is assistance of counsel, obviously the biggie, okay? But the principle comes from the same exact place with compulsory process, and that is that back in the day, in England, in common law, you did not have a right to counsel, period. There was no right to counsel. Now, if you had money and you could hire your own private lawyer, you could petition for your lawyer to represent you. But if you were indigent, if you didn't have money, it didn't matter what you were accused of, you were not entitled to a lawyer. So, well, how does that benefit the king? Think about it realistically, right? If you don't have anybody presenting a defense or challenging the allegations, it should be a slam dunk, right? I mean, it's like a junior varsity team playing against the pros. There's no contest there. So our founding fathers decided we're not going to tolerate that. Again, this is more Star Chamber stuff. We're going to allow the defendant, apart from being all of these other things that we've talked about, and being able to confront witnesses in a public setting in front of a jury that is impartial, we're going to allow this defendant to present a defense. And that means that we're going to allow them the same type of leverage that the government has. The government's going to subpoena witnesses. The government's going to bring evidence into the courtroom. Well, so too can the defendant. The defendant's right to put forth a defense cannot be abridged. So we have the right to send out subpoenas, to compel witnesses to appear, to seek to have them held in contempt if they don't appear, to seek documents vis-a-vis subpoena ducis tecum, or any other method that we wish to employ. We sometimes use our investigator to go out and gather witness statements or surveillance video or whatever it may be. All of these types of things have to be afforded to the defendant as just your basic fundamental fairness to kind of level the playing field, or at least try to level the playing field inside of the courtroom. Mm-hmm. Is there anything you want to add to that, Ed?
No, I think you're right. I mean, I was going to add briefly the case I recently had. It's in the Herald, so it's not like I'm violating.
A little shameless plug there.
No. I'm not violating any attorney-client privilege. I don't really need to ask my client because it's public record. I'm not going to get into too many details. But the case that I recently did, if you read the police report and you hear the cops, it's a no-brainer. It was absolutely no doubt that my client committed the crime, that he had stolen money. There was no doubt that he stole the money. It was just like, why are we even here?
Yeah, but did he pay his lawyer?
Because what?
But did he pay his lawyer?
Yes, he did.
That's the first step towards rehabilitation.
But here's the thing. Once I was able to cross-examine the officers and my client testified, now the trier of fact, which in this case we decided to do it with the judge instead of a jury trial. Now the judge really, I mean, she literally at one point said on the record, I have to go think about this. And she never made a decision beforehand. She didn't say beforehand, "Oh, I know he's guilty." But everyone that ever saw the case, outside of the judge, who was the trier of fact in this case, it was a slam dunk for the state. There was no doubt that my client stole the money. But because he was allowed to put on a defense, and I was able to ask some questions that they didn't answer in their reports, I was able to get stuff out from them that they didn't even talk about in their reports, plus my client testifying. Now the judge, or in this case, a jury, if we're doing jury, gets a full effect. They get to see the whole thing from all angles, from all sides. And yeah, sometimes it shows that maybe they're wrong, or sometimes at the very least, it shows, you know what, it wasn't that clear cut. And that's really all you need in America, because remember what Ben Franklin allegedly said: it's better 100 guilty men go free than one innocent man be prosecuted. And that's the mindset of the American jurisprudence. This is not how it was in England. In England, it was, look, if one innocent guy goes to jail, as long as we get 100 criminals off the street or whatever, or get 100 guys that the king is pissed off at in prison, that's fine with us. When they came here, they had a different mindset. We need to be brutally, perfectly sure that that person committed that crime. And that's why it's beyond and to the exclusion of every reasonable doubt.
All right, let's get on to our next one. This is the biggie. This is the one that everybody thinks of when they think of the Sixth Amendment. It's the right to assistance of counsel. So I want to read you a quote from the Supreme Court case that's credited with really making this right meaningful. And that didn't happen until 1963, by the way. So,
Really?
you know, you can imagine it was close to 200 years before this actually became really, really mainstream. But the case of Gideon versus Wainwright says, quote, "In our adversary system of criminal justice, any person hauled into court who is too poor to hire a lawyer cannot be afforded a fair trial unless counsel is also provided to him." So effectively, again, it's an effort to level the playing field. Remember, back in common law times, back in England, you did not have a right to a lawyer. You could hire one if you wanted to, and the court or the king may allow your lawyer to speak or not, could wind up in the cell right next to you. But in any event, we decided as a newly formed nation, we weren't going to have that. Anybody who gets accused is entitled to a trial. And maybe one of the best examples of that is actually pre-Declaration of Independence. And that would be John Adams's representation of the British soldiers during the trial for the Boston Massacre. He represented them, and he represented them pro bono, and he represented them at great personal cost because the tension was so high and the hatred was so high. But John Adams' conscience was, I don't care who you are. I don't care what you're accused of. It makes no difference. You are entitled to have your version of events heard. And so that trial occurred literally at the bar, as they used to do it, standing in front of the bar. And so that's a great example. If you guys have never seen the HBO miniseries John Adams with Paul Giamatti, make sure you watch it because it's just fascinating.
Believe it or not, I've said this to many of my clients, and honestly, most of them understand. I don't think I've had I can't remember one that didn't understand or got upset. But sometimes I've told my clients, I am not representing you. I'm representing the system. I'm representing you. But you got to understand what I'm doing here is it doesn't matter to Michael or I if you're innocent or guilty, if you did it, none of that matters to us. So we need to make sure you get a great representation, because even if you did it today and you're the one that's guilty, we need to make sure that the entire system, that the cops, the judges, the prosecutors know that there are lawyers out there that are going to make damn sure that you got the right guy.
Just
so
as
that the next time it's not somebody innocent.
Just as a little snarky aside.
You snarky? Never.
So every now and then you come across a prosecutor that's a little overzealous, right? Prosecutors will always introduce themselves to the jury, and they will talk about whether it's during jury selection or opening statement or both. And they'll talk about how they represent the people of the state of Florida, right? It's their little way of giving them some extra fluff and some extra authority, right? And, you know, stand up a little more than the piddly defense lawyer that's sitting there on the other table, right? Look, I usually just let it go, but when I have a prosecutor who goes out of their way to really highlight that and make a stink out of it, I just sit there and wait for my turn to get up there and say, you know, the prosecutor told you they represent the people of the state of Florida, and that's entirely true. But guess what? I represent the people of the United States of America. I represent the Constitution. I represent the Sixth Amendment right to counsel. And then I just throw it right back at him. Now, look, it's snarky and it's really not nice. But if you have a prosecutor that goes overboard, the truth is that's what we are there to do.
Well,
We're there to defend our client. But more importantly, we're there to make sure that our client gets a fair shake. All right.
I can tell you this.
Now, I've said, hang on one second.
That,
I've said this a million times, and I'm going to say it again and be real clear about it. When Ed or I or any other lawyer gets hired on a case, almost every time, I mean, there is the exception to the rule where a client will come to us before an arrest occurs, but almost every time it's already after the arrest has happened. The client is already engaged in whatever behavior they have engaged in. They've already made whatever statements that they might have made, if any. They already took whatever physical examinations or provided whatever evidence they may have already done. There is nothing that Ed and I can do to go back in time to change it. But what we can do is if there was some procedural or substantive or constitutional or factual or legal violation, we can try and get that remedied. But more importantly, from the moment that we come onto the case, we draw a line in the sand. And from that moment on, our job, apart from providing advice and counsel and representing you effectively, is to make sure that your constitutional rights are respected by everybody, the judge, the prosecutor, and the jury from that moment forward. So that's what we're there to do. So what does the right to counsel mean? It means that you are entitled to an effective, competent attorney. Does not mean that you're entitled to the attorney of your choosing, although in one way it does, because the Sixth Amendment is very clear. The Supreme Court has been very clear in interpreting it, that you, as a criminal accused, are entitled to hire any lawyer that you want. Now, you're not entitled to have anybody you want represent you, right? In other words, I can't have my cousin Billy, who happens to be a great arguer, represent me unless he's also a licensed lawyer. But you are entitled to have any licensed attorney that you want. So if you are stupid enough to want to have your wills and trusts lawyer represent you in criminal court, that's your prerogative. The judge is going to ask you about it. They're going to get it on the record. They're going to make sure that you're making an intelligent decision, but they have to honor your Sixth Amendment right to the counsel of your choosing. So what happens if you're indigent and you can't afford a lawyer? Well, one has to be given to you. The government needs to provide you. The court needs to provide you with a lawyer. So who is your lawyer? Again, this will vary from place to place. So let's just talk about Florida. The first tier is what we call the Office of the Public Defender. Just like Ed was talking about, every state attorney's office and each of the 20 judicial circuits has its own state attorney with its own state attorneys and its own judges. So too is there an independent public defender's office. And the PD's office represents people who cannot afford to hire counsel of their own. But what happens if your public defender is conflicted out, which can happen for any of a number of reasons? Well, we have what's called a second tier public defender's office, and that is called regional counsel. So each of the 20 judicial circuits, also apart from having its own public defender's office, has its own regional counsel office. And if the PD is not capable of representing someone, then it goes down to regional counsel to do that. And if regional counsel is not available, the third tier is what we call CAC, or court-appointed counsel. And court-appointed counsel are private lawyers like Ed and myself, although I don't do CAC work. I don't believe Ed does either. But private lawyers such as us will sign up and agree to do CAC work with the court. I did that when I was a younger lawyer. I handled my share and then some. I don't do it presently anymore.
Believe it or not, I'm actually thinking of doing it again, Mike.
I do pro bono.
I want to give back. I've been blessed.
I do pro bono, which is different. Pro bono is private lawyers doing on their own as they wish.
I do that too. But I think I want to start doing the CAC. I want to just point out something you said about a prosecutor quickly while you're looking through your notes. And I know that not very few, but it's not as common as it should be. Let me put it that way. The prosecutor's job, believe it or not, and this is the way I was trained. God bless the people that trained me that are still around. One of them is now a judge in Broward, Frank Leday. David Paulus, who I love dearly, was probably my best friend in this profession, who passed. Fred Kirstein, who's also passed. It was ingrained in me from day one that a prosecutor's job is to do justice, not to prosecute. Prosecution is not justice. Justice is looking at the case, making sure that the person is guilty. Forget what the cop says. You look at it independently, and then assessing what is the appropriate remedy. Is this a person who needs to go to prison? Is this a person that maybe needs probation? Is this somebody who with PTI? Maybe they'll learn their lesson. We were not. We were trained. We are not there to prosecute. So we're not there to play smarmy games and be an asshole when we're picking a jury and trying to convince the jury that I'm right. The job of a prosecutor, if it's done correctly, is he's just going to lay out the facts. He thinks he's right, but he really shouldn't have any stake in the game. He should be looking at let the jury decide because that's their role. They are the ones who live in the community. I mean, we technically do too, but at that point in the game, you're not. You're just the hired gun, man. If they want to prosecute this guy, fine. If they want to let him go back on the street, that's fine too. And I see lately that has changed a little bit, and it's a little concerning to me, Michael, because that's not the prosecutor's job. It's to be.
Let's get on to the defense attorney's job, okay? show video 11A, please.
You got the right to remain silent, so shut the fuck up, okay? You got the right to an attorney. If you can't afford an attorney, we will provide you with the dumbest fucking lawyer on earth. If you get Johnny Cochran, I'll kill you.
All right, you can kill it. So that's obviously one of the Lethal Weapon movies. It's it's a funny take on the Miranda rights, but it's not necessarily untrue either. Right?
But for one part, I have exception with one part.
Yeah, what is that?
When he says that they'll provide the dumbest lawyer on earth. Listen, public defenders get a lot of slack, and
I agree with you.
Crystal clear. There are some public defenders that I would want representing me if I got arrested. They're amazing. But it's like everything else in life. You have some public defenders that are not as good as others. Some prosecutors are not as good as others. Some judges that are not as good as
there
others.
There are private lawyers that fall into that category too. So
private lawyers that are not as good
lawyer.
as others. There's pastry chefs that are not as good as others. Right? But some of them are very good.
Let me run into our last couple points.
But wait, I just want to get through the last part. You have time. But the difference between a private lawyer and a public defender is this. Even if they are equally skilled, exactly the same skilled, the public defender will typically have a lot more cases. And he just can't dedicate as much time to your case as a private one. That is true. But that they're bad? No. Not.
I need to say a couple more things here.
No.
So I want you all to know that again, when it comes to court-appointed counsel, you're entitled to an attorney, but you're not entitled to the lawyer of your own choosing. So if you're not happy with your public defender or your court-appointed attorney, you can file a request with the court that your PD be changed. But in order for that to happen, the court's going to need to conduct what's called a Nelson hearing, where they listen to whatever grievance it is that you have about your lawyer, which has to be very succinct. It's got to be articulate. You can't just say, I'm not happy with it. You have to have a legitimate basis for your complaint. And then, of course, the lawyer has an opportunity to rebut that. The court gets to decide whether or not you're going to get a different court-appointed lawyer. But this takes us to the last category of people. And I don't want to call out any particular groups. You know who you are. But there are some of you out there who think that you're better lawyers than your lawyer. You know more than your lawyer. And therefore, you want to self-represent. Please put up slide 11B. I have a constitutional right to represent myself, and I have a constitutional duty to advise you that exercising that right makes you an idiot. Take that one down. Thank you. Abe Lincoln famously said, he who represents himself has a fool for a client. Very briefly stated, the United States Supreme Court, in interpreting the Sixth Amendment, has said an individual has an absolute and unequivocal right to self-represent. You cannot force a lawyer on anybody. But in order for a court to accept somebody's right to self-represent, they have to conduct what's called a Feretta inquiry. And during the course of that Feretta hearing, basically what the judge needs to do is decide whether or not you are knowingly, intelligently, and voluntarily making this decision. Nobody's holding a gun to your head. You're not suffering from a major mental illness. And if that's the case and you want to do it, the judge is going to recommend that you don't do it, but you are entitled to do it just as you are entitled to hire your own lawyer. You are equally entitled under the Sixth Amendment. It is absolutely black letter Supreme Court law to self-represent. The last thing that I want to get to before we get done, please put up our first slide under 12.
You know, I give you
okay. So you see who that is right there? Who is that?
Looks like you, but too much hair.
Take it down. That is a founding father strapped down in his grave. You want to know why that founding father is strapped down in his grave?
Are you asking me? Yeah, I'm on pins and needles.
I'm going to tell you why. I'm going to show you why. Go ahead and put up slide 12B, the second one. That's why. Because we don't want them rolling over in their graves. Thank you. You can take that down. Why am I telling you this? We're going back to where we started here. Hashtag up X2. Shut up and lawyer up. Every single time that somebody waives their Fifth or Sixth Amendment rights, or for that matter, their Fourth Amendment rights when it comes to consenting to searches and things along those lines, founding fathers absolutely roll in their graves. You have to understand that these people in the late 18th century gave their everything. They gave their lives. They gave their families' lives. They gave their property. They gave everything that they had to ensure the democratic republic that we have today would be here. They gave it all up for you. They gave it up for their progeny. They gave it up for our children. So when we flagrantly throw these constitutional rights to the ground and pretend that they're irrelevant or pointless or meaningless, or they're just not valuable, or we don't like them anymore,
Or they're just
whatever the
something
case
written
may
on
be,
a piece of paper. I love that one.
whenever you get to that type of a thing, you have to understand the history of it to understand the depth and the meaning behind it. These people, you don't want them rolling in their graves. I don't want them rolling in their graves. We want them to sleep well because we owe them a debt that we could never repay. They gave everything for us. What have we done for them?
Well, the thing is, a lot of people who think like that, Michael, also I've noticed have never lived. Because one thing to vacation, live in another country where you don't have these benefits, and you'll understand exactly why they would be rolling over in their grave. Because that's what they came from. They came from a country where you didn't have these safeguards. And so it would really upset them because they worked really hard. And no, it's not something written on a piece of paper.
It's not just
It's an
work.
idea.
It's not just work, because while these guys were sitting in Philadelphia drafting documents, there were tens of thousands of people dying on battlefields, right? I mean, it was years long, and battles uncountable, blood soaking the soil. So there's more to it than just a piece of paper. That piece of paper
Much
only came to exist because of the sacrifice, not just of time, of effort, of energy, of property, but of life, of blood, of family, all of those things. So what happens apart from founding fathers rolling in their graves? I like to jokingly say, listen, when Martinez or I go to court for you, I think you want us in an Armani or a Canali suit, not a hazmat suit. And if you make a mess out of your case before it comes to us, that's exactly what we need to wear in a courtroom, is a hazmat suit, because we got to clean up the mess that you made, and it's toxic. So please, whatever you do, just remember up X2, hashtag up X2. It means invoke the 5th, shut up. Invoke the 6th, lawyer up. There is a time and a place and a location for every argument. It is never on the side of the road with the police officer, ever.
Never in an interrogation room.
You may
Never.
be able to, you may very well be able to talk your way out of something. I don't deny the fact that some of you are very talented and intelligent, but there's a better chance that you're going to talk yourself into something, and that someone like Ed or I are going to have to put on the hazmat suit to clean up your mess. With that said, I think we've concluded AYS 42, unless you have anything else that you think I missed.
No, what you missed. I don't know. You missed nothing. I can't give you 3. This is what happens when I give you 3 weeks. How many slides did you, like 12 slides? You're killing me, man.
Well, it's only because I did so many on the Up X2 Part 1. We also had a good number of slides. But I think, look, the slides are fun because they give you a different perspective. And I really do like that. I really do like the Chris Rock one with regards to the Miranda rights. We could have shown that in Up X2 Part 1 just as easily. But
no, it's fine. I'm messing with you. But you're absolutely right in everything that's been said here. But I just want to point out one thing in closing. When Michael talks about getting a lawyer, it's not because we think we're better than you. We're not smarter than you. I am telling you, I don't know what Michael's opinion is, but in my opinion, you don't really need much more than above average intelligence to be a lawyer. Okay. Anybody can be a lawyer if you're even middle of the road. What we do have is akin to, let's say, an airplane mechanic. I know a lot of people. Look, I used to fix my car. I restored my own 65 Mustang. Sure, of course I did it. But there's a big difference. If you told me, Ed, you're going to get in that car and you're going to drive and your life depends on it. If it breaks down, you die. You think I would fix it myself? No, I'd get a mechanic because I want to make sure everything
Mad
goes
Max would
right.
fix it himself.
Well, he'd have no choice. But I guarantee you, if he had a master mechanic, he would have had that. He would have kicked that dog out of the car, and he would have the master mechanic there. When your life depends on it, don't screw around. Get somebody who knows what they're doing, who's done it, who studied it, then worked it, then did it, knows every which way to go. I know I have forgotten more shit than I know. Okay, so and Michael too. Right? How many times do we talk and we go, oh, you know what? Remember this? I did this in a case. You know, one is about 17 years ago. I remember we had this issue come up on a case. So that's not going to happen with you. You're not fixing your car in your garage. This is your life. If you want to represent yourself, you're an idiot. You really are just an idiot. So, look, perfect time.
Well,
122.
With those wise, sage words of advice, I want to thank everybody for joining us for At Your Service episode 42 today. We hope to be able to come back next week on the 27th with episode number 43. I have no idea what we're going to talk about, but we'll do our best to offer you some pro tips, to be entertaining, to be informative, and
that's our pro tip for today. Don't be an idiot.
And with that, I want to thank Martinez for coming. I want to thank our production crew for helping us and being so wonderful with all of the demonstrative tools that we used. And I want to remind everybody that this show will be uploaded to YouTube. And as soon as the production crew does that, they'll send us links and I'll put them up all over the internet so you'll have access. Thank you again for joining us today. Y'all have a great week.
Bye, everybody.
And we'll see you next week.